Broken up, but it's still stock. But that, you know, didn't get enough facts get set as well for railroad.
Yeah, but one Erie has so much.
Right.
And then Clarence.
Yeah, Clarence is fame. Although I guess GMO is so far off.
Complaint on the record here. And then she goes, well,
He has a bunch of different cultures. And a lot of it, people
But I told her. Yeah.
That's the first time I've heard that hate.
Yeah.
it's really offensive. It's offensive.
So they have all the time in the world.
But he, I recall, when he first went into the race,
30 years ago. Exactly.
Most of the day. I'm on video. Just texted me and said, just saw you walk in. Hi.
Clearly, there's no
No, it's okay. If you heard the flu, actually, you know. Yeah.
So, she said that on the record. They don't, they when I asked her, just she was a supervisor. Are you an attorney?
This is weird. I didn't realize it was a thing.
yeah, well, I like the policy of the DA because of the
Actually, they tell me.
Where the I would tell my clients,
yeah. But at least it's back from where they are.
She didn't have a file. She didn't have a file, so I had to class by the time I was here.
Decisions.
And you were struggling with Wi-Fi.
Then they respond to feel well.
They always ask for and also to, it was.
Probably doing it first, but then you start thinking, get away with that.
Yeah, that's what I
I mean, it's rest, it's learning it.
But
Well, everybody shows up to court probably is being discouraged.
Yes, you're my old brother. Okay, that's fine. We call it disco band, whatever. It turns out that I didn't know him and he brought in everybody who was anybody, and so
That bunch of old songs.
I'll squeak it out. Pretty quiet year. Decade for him. He tried to make some noise with the Stone Canyons and the whole country.
Let's over and see everybody who's here and that. Who's in the audience, you can nice. No, I had to give them. John Gorman, Judge Gorman's son. Yeah, he would have to. I think probably this year, because I think he gets appointed just to the next, right, just to get into the next cycle. Interestingly, though, it's everywhere.
Yeah, they said
Everybody must have to read out.
Yeah, year.
Yeah. Are we ready? Nick, are we ready? Are we taping?
Yeah, we're good.
We're good?
It's the live stream.
Okay. Hi, can I have your attention, please, folks? Welcome to our facilities at the Assigned Counsel program, our training room. We appreciate everyone coming. Looks like we have a full house. We have a capacity of about 50. It looks like all of our seats are taken. I'm very happy to see that. As always, we'd like to extend a thank you to ILS and Bill Leahy and the folks in Albany who have provided these the funding that makes all of this available. It makes available both Judge Franzak, our CLE director, and Nick Texedo, our writing and appellate specialist, and it makes available the facilities that we have here. So we're very appreciative to them for all that they do on our behalf, and that trickles down to our clients because you guys get the benefit of excellent CLEs, free of charge, by the way, on issues like this, Evidentiary Foundations. And we'll get to that in just 1 second. But I am very happy to see that we have a full house. And I also think that over the last couple of days, I've gotten some really positive feedback on our forensic work group that we're putting together, practice group that we're putting together. Alicia Lilly, ex-ADA, is going to be a welcome addition to our family here at Assigned Counsel. She's extraordinarily bright. She has an intellectual curiosity that is really perfect for the job. I met with her over 2 or 3 interviews and was very impressed with her grasp of the material that we're going to be delving into. She's going to be heading up a unit. We call it a practice group, but as part of it, it's going to be case strategies involving more complex litigation, cases that involve DNA and or other forensic or scientific evidence. Tim Crino, who we have laid out in that email, actually he was supposed to start Monday, he came in yesterday. So he's very eager to start too. He's excited about the proposition of building a panel of experts. When I got here about 1.5 years ago, I asked Ellen, who's been, us older guys, Ellen, that if you needed any type of expert or transcripts and stuff like that, Ellen was the person to go to. So I asked her for a list of our experts, and she gives me this list, and none of it was, categorized. It was just an alphabetical list of names. I didn't know who was who and what was what, and that's going to change. We're going to have a brand new website coming out in February, and it's going to be broken down. Half of it's going to be right the second you bring it up is the Assigned Counsel program. You're going to notice that there's a change in the atmosphere at Assigned Counsel. On one side of the screen is you're going to be able to access the criminal panel, and on the other side of the screen you're going to be able to access the family court panel. And we are going to have a fully developed websites on both sides. So if you're accessing the family court side, you'll be able to access everything that we have to offer to the family court panel. And on the criminal side, we're going to have a fully developed website also where you're going to be able to get briefs. You're going to be able to find out this list of experts. And as you scroll over their name, it's going to give a brief biography. It's going to tell you what they do, what type of expert you're looking for. It's going to be broken down into categories: pathologist, anesthesiologist, dog bite, fingerprint, DNA. It's all going to be laid out, so it's going to be very easy to access the name. And then it's all you'll do is go to Defender Data like you do right now, and request the expert through the pre-authorization tab. So very easy, but hopefully that'll be something that you guys will be able to utilize to its fullest extent. What else do we have going on that I wanted to let you in on? I don't know. Not much, actually, other than that.
which is a pretty big bite of the apple, so to speak. So we're very proud of that. We're happy to be able to offer that to you. All of the services that we offer, our investigators, we're having trainings with both the investigators and the social workers, and we're bringing everybody in as part of a mandatory training. And really, what the training is what the services are that they are able to provide to you, and how to best access them. So you might be sitting back saying, well, what do I need a social worker for on this case? Well, they'll be able to tell you what types of cases they are most effective on. Or why am I going to get an investigator? Is it just to go visit the crime scene? Well, maybe not. Maybe you need an investigator to serve a subpoena. So they will give you the highlights. You may have concerns. I've had a lot of panel members come to me and say, oh, well, if I say something to the investigator, is it confidential? And it is. All of the information that you share back and forth is confidential. John Angie cannot get into any file that Joe Terranova is representing an individual on. Our data defender, electronic monitoring system, electronic case management system, it's the equivalent of having your own separate office. You wouldn't be able to access somebody else's office. You can't access the information on somebody else's case file through the defender data system. So concerns about, can someone access information that the investigator gets to me? It's more secure than your email. All right, people, how many times have you seen that? My email was hacked. We haven't, knock on wood. Now it's going to happen. You know that, right? Now we're going to get hacked, but we haven't been hacked. It's a very secure system, and so I encourage everyone to utilize the resources that we have available. And in the upcoming year through 2020, we are making more requests for other resources that will be available to you. If you haven't noticed, I'm sure you have, we have a bench that's built here. And so next to this, it's on wheels. It'll be moved over to the center of the room, and we're actually going to have smaller groups of panels come in and do actual trial technique. And we'll have a witness stand that's also going to be part of this. And it's going to give younger and more experienced attorneys that real life, because we got a judge, that real life feeling of how it is to be in a courtroom. All right? Putting these evidentiary foundations into practice, all right, in a real courtroom setting, or at least as much as we can make it a courtroom setting. All of these CLEs that we're doing now are not only taped here, but they're live streamed out. So all of the folks who are watching in other jurisdictions, we welcome you. We thank you for participating. We know that there are individuals and groups that are watching, so we thank you for your time. And all of the resources that we're talking about here are things that we are hoping to share with other jurisdictions at some point down the line. So all of the things that we have to offer, I'm encouraging you to consider. And if there's any question whatsoever as to whether or not a resource is available to you, such as an investigator or a social worker or research, or having someone prepare a memorandum for you, or a mitigation specialist, if anybody has any question, you can either call me, everyone's got my phone number, or you can access those through the Defender data system in the notes section and just alert me or task me, and I'll make sure to get back to you as quickly as I can. So I know I took up some of your time, but I haven't been in on a few of these CLEs in a while. I miss seeing everybody. I don't see you guys, folks, as much as I'd like to. But Evidentiary Foundations by the judge and Nick, you'll be glued to your seats for the next 2 hours. So enjoy, and again, thank you very much. And again, thank you to ILS and Bill Leahy and all of the funding that we received from the Harrell hearing settlement. It's greatly appreciated. So thank you guys, and enjoy the presentation.
Okay. Just one more thing, just to mark your calendars. On March 27th at 1 o'clock, that's a Friday, we'll be putting on a CLE. We're bringing in a gentleman from the Center for Appellate Litigation downstate. His name is Bob Dean. He's a very well-regarded appellate attorney. And he's going to give a presentation that's actually geared toward trial attorneys, which is on preservation of issues and also easier ways to get foreperson relief for your clients so that they can get an appellate attorney assigned. Bob Dean has argued before the Supreme Court. He's been an appellate attorney for 40 years. We're putting that on in conjunction with the Legal Aid Bureau of Buffalo. So both agencies are participating in putting that on. We're going to have it here at 1 o'clock on that day. It'll also be available live streamed, and for the people who are watching this from other jurisdictions, we'll get you that information as soon as possible. So just mark your calendars for that. We're really excited about it. And we want to continue to bring people in from other jurisdictions and more well-known people, and so you don't have to listen to me and the judge all the time. So just mark your calendars for that. As far as today goes, this is kind of a two-part thing. You'll have me first, then you'll get a break, and then you'll have the judge. So I'm going to talk about foundations of different kinds of evidence that you might want to be putting in at your trial, or that the DA may be trying to put in at your trial. And then the judge is going to talk about hearsay, what it is, what it isn't, and what the exceptions to hearsay are. I think this is really important, especially now, because you're going to be getting a lot more stuff. First, the discovery rules have changed, so you're going to be getting a lot more from the DA. Second off, you all have access now to investigators, so you may be compiling a lot more information than you used to. So it's really important to know how to get that information in if you deem that it's beneficial to your client, to your case. So a lot of this you might know already, but it's always good to have a refresher. And what we're going to do is go through, we'll have an introduction, we'll talk about testimonial evidence, evidence that bears on witnesses' credibility, then documentary evidence, some of the different kinds of documentary evidence you might encounter and how that goes into evidence, judicial notice, photographs, video, social media and text messages, which I leave till the end because I think that's one of the more important things that we'll talk about. It's becoming more and more prevalent in our practice, and physical evidence. So by way of introduction, I want to talk about kind of the formula that John Nucciarino used to say regarding admissibility of evidence. And it's R plus R equals A. Relevant plus reliable equals admissible. So if a piece of evidence is relevant and that piece of evidence is also reliable, then it's going to be admissible. And when we were going over this earlier, the judge brought up, well, only if its probative value isn't exceeded by its prejudicial effect, which is true. So I would, I guess, add that little disclaimer. But for all intents and purposes, this formula really applies to any piece of evidence. Relevance. Evidence is relevant if it tends to prove or disprove the existence or non-existence of a material fact. And evidence is reliable if it's offered by a person with direct knowledge, or it falls under a hearsay exception, or it's a document, a recording, digital or real evidence provided an adequate foundation is laid. So that's the whole framework under which admissibility is really determined. Is it relevant and is it reliable? We're not going to talk a lot about relevance here, although foundations do go to relevance, because if you have to tie, say, a text message to a certain witness in order for it to be relevant, your foundation is going to be what shows that that text message is relevant. So we're going to start off with testimonial evidence. It's the most common form of evidence, and that's when a witness gets on the stand and a witness testifies to some fact or opinion. So in order to testify, a witness has to have personal knowledge of the subject matter or some relevant fact, or in the case of an expert, some relevant opinion. The witness has to be capable of understanding the nature of the oath or affirmation, and the witness must be capable of expressing the fact or opinion. So that's really all testimonial evidence is. It's someone who gets up to the stand and says, yeah, I saw the defendant steal the can of soup from Save-A-Lot. That's really all it is. That witness has to be capable of understanding the nature of an oath. All witnesses that are of age are presumed capable, and witnesses who are younger than that age can be shown to be capable by a showing by the DA. And the witness has to be capable of expressing that fact. So that's really it. So we're going to go through the different ways that you may attack or support the credibility of a witness. Because a lot of them have foundational requirements that you have to meet before you can get to that. So the first one is bad acts that did not result in a conviction. So you have a witness who's testifying, say, against your client, and you want to cross-examine that witness on some bad act that you know or you have reason to believe they committed, but they maybe were never charged or never convicted for that bad act. Number one, you have to have a good faith basis for asking the question. So you can't just ask the witness, well, you killed a dog when you were 12, didn't you? If you have no reason to believe that that witness, in fact, committed that act. You have to have some good faith basis for asking. You don't have to have proof beyond a reasonable doubt or anything like that, but you do have to have some good faith basis. The problem with this type of cross-examination, though, you're limited to your cross-examination and you must accept the answer. You can't produce any extrinsic evidence to support it if the witness says, no, I have no idea what you're talking about. So let's say you know the witness had previously committed some type of theft, but they were never charged, never prosecuted, never convicted. You can ask them the questions about that, but if they say, no, I have no idea what you're talking about, you're stuck with that answer. You can't bring in any type of supporting documentation or support to show that they did in fact commit that act. But the foundation is you ask them when and where they committed the act, and then you can argue that the nature of the act reflects adversely upon their credibility, that it's immoral, vicious, or criminal conduct. Yes, Amy?
Nick, what is the authority for the third point?
That you're limited and you must accept the answer?
Yeah.
It's
Where's
case
that
law. I generally put the case law into this presentation where it's stuff that you can use and stuff that will help you. I think in this case, it's not going to help you, so you're not really going to need the case. It's going to hurt you. I didn't put a case in there. I can email you one after the presentation.
If you happen to be in federal court, it's 608.
Okay, and yeah, under the federal rules, it's 608, but New York, the rules of evidence are primarily case law driven or driven by the CPL and the CPLR. So this is one that is case law driven based on the federal rules. But that is the rule. So just be careful when you're doing that. And you know, it's a situation where you want to be careful then how you structure your questions. You might want to get into this a little more delicately, get into it a little earlier before you start beating up the witness on all their inconsistencies. Get into it while the witness is still in a mood to be agreeing with you and to be conceding things. And that's something we've all learned, you know, concession-based cross-examination, where you get all the concessions out first before you start beating on the witness while they're still in a mood to be conceding things. Yes, Frank?
Can you use extrinsic evidence to refresh a recollection without seeking its admission?
So if they say, I don't recall that, then I think you'd have a good argument because you can use anything to refresh a witness's recollection. So again, that could be the way you structure your question. If you say, do you recall committing a credit card theft in 2005? No, I don't recall is a lot different than no, I never did that. So you can say, well, if I show you this document, might it refresh your recollection? And while I was doing that, the judge, Amy, I can answer your question now on the case law support. People v. Duncan, 13 New York 2nd 37, which is a Court of Appeals case.
Thank you.
Okay, and so that's, again, it's important how you structure these questions, because if you can get the witness to say, I don't recall, then you can use the documents to refresh their recollection rather than impeach them or admit the evidence. So that's a good point by Frank. Prior convictions are a little different because you're not going to be stuck with the answer. So you have a witness who's testifying against your client who has a prior conviction. And this could be for a crime or an offense. So it can be disorderly conduct up to murder. You can establish that they have a prior conviction, that it's for some crime or offense. You have to ask what jurisdiction it was entered, what year, what sentence they received. And you can get into the underlying facts. And I think this is really important. And I think a lot of the criminal defense attorneys do this already, but it's very important when the DA discloses that a certain witness has a criminal record or some kind of conviction, you need to go and get the file so that you can get into the underlying facts. Because it's a lot different to ask a witness, well, you were convicted of disorderly conduct in 2005, weren't you? You know, that gives you one level of value. The other level of value might be the underlying facts. Let's say the facts underlying that, people get discounts on a lot of different variety of cases. Maybe in that case, the witness had a fake license. They're pulled over, they have a fake license, they run from the cops, they have drugs in their car, and they're fighting with the police when they get arrested. You can ask them all those questions, and that gives you a whole different level of value than just you were convicted of disorderly conduct. So it's going to be really important to get the file. Yes, Joe?
Nick, one of the problems we ran into before current disclosure rules was that you'd run out of time. You'd get this stuff during Rosario, during jury selection. And what do you have to say about a sealed file?
So with a sealed file, what you would have to do is move to the court where your case is pending for an order unsealing that file. So the DA does have to disclose, and now with the timing, it's now 15 days after arraignment on the accusatory instrument. The DA is going to have to disclose the conviction, and that includes violations. And the DA now also they can't claim ignorance. They have to run a rap sheet on their witnesses and become aware of it. So you're going to have it a lot earlier, and you'll have time to do a motion to unseal. And I think you can, I think you'll be hard pressed to find a judge who's not willing to grant that motion. If you have a material witness in your case who has a prior conviction, and you say, Judge, in order to properly cross-examine this witness, I need the records of that case unsealed so that I can get into the facts of that. So that's something you will have to do if you have a sealed file, like a conviction for a violation or something of that matter, or if you become aware of even a youthful offender adjudication. On those, you can get into the facts, but not the adjudication itself. Lana.
Just to follow up with Joe's question, an example from a real case. During the felony hearing, the witness testifies that they met the defendant while in placement as juvenile delinquent at one of their facilities. So does that apply to juvenile delinquency matters that are sealed as well? And at what point you make such a request to the judge? If nothing presented as Rosario prior to felony hearing due to the people claiming that JD proceedings are sealed.
So the question was for the people live streaming. I think everyone in the room heard, but I doubt the people listening at home heard. If you have a witness who you've become aware has a prior juvenile delinquency adjudication and was placed for that adjudication, how do you navigate that? And I believe it's the same thing. You'd have to make a motion to unseal that with the trial court. And the argument is, how do I properly cross-examine this witness unless I know what the facts underlying this adjudication are? And the court, in that case, with a conviction, I think you'll be in really good shape. With a juvenile delinquency adjudication, it'll come down to your ability to convince the judge that it's material. And something to fall back on is always, well, Judge, I think you should maybe review the records in camera and decide then what should be disclosed to the defense for cross-examination. And judges will often be willing to at least take that step for you. Yes, Amber.
In cases where you are dealing with suppression issues or maybe even making a motion or a memorandum post-suppression hearing to the court that in particular and specifically involve law enforcement officers who you then come to find are maybe on some sort of administrative leave or have been disciplined or something like that, that's going to be a really weighty issue for credibility of whatever testimony may have been offered during your hearing. So what would we do to go about that? Because I know there's certain, it's a heavy fight to get disciplinary records for law enforcement officers, and not a lot of judges are willing to tiptoe into that. So what would you say would be the best avenue to explore something like that?
Well, so the question is, if you become aware, and I think the timing you asked was after a hearing's over?
Or
So
prior. Right
okay,
now
or
I have
prior.
one where we have 2 officers on administrative leave,
Okay.
and we found out prior to the post-hearing memo of law.
Okay, so the question has a couple of parts. First, if you become aware of any information after your hearing but before the court renders a decision, you can move to reopen that hearing, convince the judge that it's relevant and that they should hear it, and that the court can, in their discretion, reopen the hearing prior to issuing a decision. That's number one. The question was, though, obtaining records of law enforcement witnesses who might have misconduct adjudications. And if the DA is aware, they have to disclose it. That's a rule. And the DA's office in Erie County, at least, is now maintaining kind of a data bank of officers who have those types of adjudications or convictions. So they will give those to you if they're aware of it. If they're not aware of it and you are, you need to explain to the judge exactly what you know and what reason you believe that this officer has prior misconduct, and then you have to convince the court to sign a judicial subpoena in order to get the records of that from Buffalo Police. And we've been successful in doing that on a few cases where people have reached out to me on their cases. We've been unsuccessful in some cases, but it comes down to your ability to convince the judge that that's something that you need and that you have enough information, because you can't just do it with every officer as a fishing expedition. You have to have some credible reason to believe that those records exist and that there was some prior misconduct. Does that answer the question?
Yeah, would that be the same recommendation then for someone who was placed on administrative leave after the testimony in your case?
Yeah, the question is, would it be the same recommendation if the person was placed on administrative leave after the testimony and after the hearing has concluded? And the answer is yes. You could tell the judge, look, I just found out about this. I need a judicial subpoena. I need the court to examine the evidence and possibly disclose it to me. And we need to reopen the hearing if there is relevant information. Now, if the witness denies, so this is where it's different when there's a conviction. Because when you have a conviction, if the witness denies the existence of that conviction, you can enter a properly attested copy of the certificate of conviction into evidence. And the support for that is CPLR 4540 sub 6 and CPL 6040 sub 1. But it has to be a properly attested copy. So while you're preparing for your trial, I always like to prepare for the worst. So I'm going to prepare as if that witness is going to deny the existence of the conviction. So in my little manila folder for that witness, I'm going to have a properly attested copy of the certificate of conviction that I obtained from the county clerk's office prior to the trial. And once you can put it in evidence without calling a county clerk, it's a self-authenticating document. So you tell the court you have it marked, you show opposing counsel, and you tell the court, at this point I'm entering this self-authenticating document into evidence. Your support is those provisions I just named, and also a case that would support that is People v. Rivera, which is on your PowerPoint slides. or on the screen, and you can enter it into evidence and read it then to the trier of fact. So that's the difference when there's a conviction on a bad act versus when there's not a conviction.
Nick?
Yes.
If I'm impeaching somebody with a prior conviction and they admit the conviction, but they deny some details of the underlying facts, am I stuck with that answer?
Yes, you are. So the question was if they admit the conviction, but they deny the existence of some of the underlying facts. You're going to be stuck with the answers regarding the underlying facts. This only applies regarding the certificate of conviction. A prior inconsistent statement, and this is the majority of what we do kind of during cross-examination regarding at least some witnesses. But I see attorneys from time to time not knowing what the proper foundation for doing this is, and even sometimes having to be helped along by the court or opposing counsel. And so it makes sense to have a little refresher on it. So when you have a prior inconsistent statement, let's say the witness testifies on direct that the car that the robber left in was blue, and there's a prior, say, testimony at the felony hearing that the car was red. You want to first show that they made a statement at an earlier time without regard to the contents. So you want to ask them, you recall testifying at a felony hearing on April 13th, 2019, or you remember signing this police statement. Then you'll have it marked, show it to opposing counsel. Then you ask the witness, so did you, when you testified at the felony hearing on April 19th, did you say that the car was in fact red? And the witness might say, yes, I did. No, I didn't. I don't recall. And then you can show the witness the prior statement in order to impeach them. Now, there can be other components to this, and I've seen attorneys do it that's the bare minimum, what you have to do in order to impeach someone with a prior inconsistent statement. But I've seen attorneys do a lot more with it. If the prior statement is more beneficial to you, you want to take steps to show that the prior statement's more reliable than the current statement. So you want to say, and that was a week after the arrest, right? That was a lot closer in time. Your memory might have been more fresh at that time. It's now been 9 months, and you've met with 4 different ADAs, and you've gotten arrested yourself. You've had 3 kids, whatever it is. You want to, depending on the circumstances of your case, you may want to show that the prior statement's more reliable than the current statement. Or you may just be using it to show that this person is a liar who can't keep their story straight. Or just that they smoke so much weed that their memory is so foggy that they can't remember anything. Whatever you're trying to accomplish, you want to tailor your questions to that. I've also seen attorneys go on and on about the oath they took at the felony hearing and how it's the same oath they took now. And that comes down to your style. You may want to do that. There's a lot of different ways to do it. This is just the bare minimum of what you have to do to lay that foundation. Yes?
How do you change the foundation if the statement's contained in, say, a police report?
So then you would, I actually prefer that, because all you really have to do is say that they signed a document.
But they didn't sign it.
Stating that. Just in a police report.
It's just in a police report.
We'll get to that later, and it's going to depend if it's a material fact or not a material fact. What you can do with this witness at that time is just merely ask them, well, do you recall telling the police that the car was blue? And you're going to kind of be stuck at that point with their answer, but there are things you can do later on in the trial, which we'll get to. Yes, Joe?
Nick, I think a real effective means for me has been if somebody says they don't recall their previous answer, refresh their recollection with their prior statement, and then ask them to read it aloud to the jury, if you can get away with it.
Right.
And that's I think
right.
Very effective.
And that's the way you can do it. And what Joe said is if they don't recall their statement, you have them read it, and then if you can get away with it, I guess, have them read it aloud to the jury.
Well,
I think the DA is gonna make some hay about that and object. But what you can certainly do is have them read it to themselves, and then you could ask them, so now after reading that, do you recall saying that the car was blue? And it's very rare to see a witness say, yeah, I still don't remember saying it. They're going to look even more like they're lying if they read their prior testimony and then say, yeah, I still don't think I said that. The stenographer was wrong, whatever it is.
Make no mistake, though, that on cross-exam of an adverse witness, whatever you call it, it ain't refreshing in fact. I mean, the witness may claim, honestly or dishonestly, I don't remember what I said before. And you can impeach that person by saying, well, isn't it a fact that in the grand jury you said it was blue? I don't remember. Mark it, show it to him, you read it to him. The only hazard in couching it in terms of refreshing recollection is that if the judge says, well, now you're refreshing the witness's recollection, all you can do is let him read it to himself. You can't, get away with it unless you're Joe or somebody else who's been doing this long enough to be able to do that. So just be careful that to my way of thinking, the only time you refresh a witness's memory is when he or she's on your side and you're helping him remember something that she forgot. But on cross, it's always impeachment, and the only thing that changes is how you go about doing it.
Yeah, and keep in mind also that the argument is, well, if there's an objection from the DA or the judge gets in your way, so wait a minute, these are this witness's words. You mean to tell me that this witness can't repeat out loud to the jury what they said before under oath?
Right.
And then, even if the judge says no, you've made your point.
Right. And just so people on the live stream can hear, the discussion was about refreshing recollection versus impeachment. And I think sometimes, the witnesses are human beings with, you never know what's going to come out of their mouths. And if you try to impeach first, but refreshing recollection is something that you're able to fall back on if the answers they give you aren't allowing you to properly impeach that witness. I think that's the takeaway from it. Now, impeachment of your own witness through an inconsistent statement. This is something that you'll see the DAs try to do a lot, but you can think of a situation where we may want to do this too. You put a witness on the stand and you thought you knew exactly what they were going to say. You have your beautiful statement that Tim McDonald took when you used an investigator on the case, and you think you're all set. You've met with the witness, you've conferenced with them, and you put them on the stand and they say something completely different than what you thought. And I know when I was a prosecutor, it would happen all the time. As a defense attorney, it happens. So this applies whether it's the DA trying to do it or you. And I think it's useful for you to know the rules, whether the DA is trying to do it or whether you're trying to do it at your trial. So it's governed by CPLR 4514 and CPL 6035 sub 1. When a party's own witness gives testimony that is affirmatively damaging, that party can impeach the witness. And that's the Court of Appeals case on that is People v. Fitzpatrick, which is in the materials. And I don't remember doesn't do it. So it has to be testimony that affirmatively damages the case. This is very important to remember because the DAs will try to do it. So they put a witness on the stand. The witness is afraid to testify or doesn't want to testify against his brother or whatever the reason is. The witness will get up there and just be like, I don't remember. And the DA is going to say, well, now I get to impeach that witness, or now I get to, in effect, cross-examine that witness. That's not the case. I don't remember doesn't do it. What does it is, I do remember, and it wasn't that guy sitting at the table, it was someone else. That's what affirmatively damages the case. I don't remember is an affirmative damage to the case. I guess, and I remember the judge putting it this way when I was trying a case in front of him and the DA was trying to do this. It's not enough to say I didn't get as much bang or as much pop out of this witness as I expected. It has to be affirmative damage to your case. Also, the party has to be actually surprised by the damaging answers. So a party can't knowingly put up a witness to testify in a damaging manner just so they can cross-examine that witness. So those are the rules. And then once you're able to show that, the foundation is the same as impeachment of any other witness through a prior inconsistent statement.
And the judge has to give a limiting instruction, if it's gonna let you get away with it, and tell the jury that that prior statement can only be considered insofar as it impeaches the trial testimony. That prior statement doesn't qualify as substantive evidence.
And that's true of any impeachment with prior inconsistent statements, and that's a good point. But it's especially important here, where, say, the DA is trying to do this. They can, let's say they're able to impeach the witness and say that they said at the grand jury that your client shot the victim, and they're now saying on the stand that someone else did. They can't then argue in summation that this witness said that your client shot the victim. They can only argue that the witness is not credible. So does that distinction make sense to everybody? Okay. It's not affirmative evidence. It's only relevant insofar as it impeaches the credibility of the witness. Terry.
Left field question.
Uh-oh.
What happens?
It's the only kind he has.
What about in the grand jury? Can the DA do this to somebody in the grand jury?
The question is, can the DA do impeach their own witness in the grand jury? Absent a few procedural exceptions that are in the CPL, the rules of evidence that are applicable at trial are also applicable in the grand jury. Unless it's in CPL 190-30, which is the exceptions, the rules of evidence at trial are all applicable in the grand jury. So the answer is no, they cannot impeach their own witness in the grand jury. And it brings up another point, that now, as of January 1st, we're getting the grand jury minutes on cases. And we've had numerous attorneys come in for case conferences where we've now been able to pick through the grand jury minutes with a fine-tooth comb, with a really critical eye, and make arguments that the DA shouldn't have been able to enter this exhibit into evidence, or the DA didn't properly establish identification, or the DA did this wrong, that wrong. We used to get them the day jury selection started, and the last thing you're thinking at that point is procedural issues in the grand jury. You're thinking, how do I impeach these witnesses? What am I going to say in my closing? But now you're getting them a lot earlier, and I think an important step in your case is to look through the grand jury minutes with an eye toward evidentiary issues and an eye toward procedural issues, an eye toward the questions the DA is asking. Did they properly show identification? Things like that. We're kind of at a new age as far as our defense of our clients goes. And it takes a lot more time and it's a lot more effort, but I think it's worth it. Evidence bearing on the credibility of witnesses. Extrinsic evidence of a prior inconsistent statement. So this is kind of the question that was brought up about, well, what if it's an oral statement and you want to still be able to impeach that witness? This is only available if it's a material issue, so not on inconsistencies dealing with credibility only. So if they say at trial, it was 80 degrees out when the defendant robbed me for whatever reason, and and the witness told the police, it's in the police's notes or whatever, that it was actually only 50 degrees out. So it's a huge difference. It's a huge inconsistency, but it's not a material issue. There's really no issue as to what the temperature was that day from a material standpoint. That only affects the witness's credibility. You're not able to then use extrinsic evidence to impeach that witness. But let's say that it is a material issue, such as who shot the victim. So this is the example, and this is the best way I could do this, was through an example, because it's hard to explain otherwise. Witness 1 testifies that the defendant shot the victim. Witness 2, the detective, has stated in a report that witness 1 said that someone else fired the shot. So you would ask witness 1, well, didn't you previously tell Detective Smith that someone else fired the shot? If the witness admits, you're done. Your impeachment is complete. You've accomplished your purpose. Yeah, actually, I did tell the detective that. You've already impeached that witness. But if the witness denies or says they don't recall, you can then call witness 2 in our case, the detective, to testify on your case as an impeachment witness when this is a material issue. And you can ask that witness the date, time, place of the statement, and the actual contents of that statement. So that can be really powerful stuff, and it's something to keep in mind when a witness has an inconsistency on a material issue. That's a way you can do that. Rehabilitation with a prior consistent statement. This is something that you'll see from time to time the prosecutors try to do, especially if you have a very effective cross-examination and you bring out a lot of inconsistencies. Something to keep in mind is the mere fact that you bring out inconsistencies and you show that this witness can't keep their story straight, that doesn't allow the DA to rehabilitate with prior consistent statements. The general rule is that prior consistent statements are bolstering and they're hearsay and they're not allowed. There is a very small exception where a party can rehabilitate their own witness with a prior consistent statement. But it's only when during cross you intimate or you insinuate that the witness recently fabricated for some reason that they have a motive to fabricate. So just when you're just hammering someone with all their inconsistencies and arguing that they can't keep their story straight, or they're a liar, or they have no memory because they're an idiot, or whatever you're trying to accomplish, that doesn't allow the DA to then rehabilitate with a prior consistent statement. And there's case law support in the materials, 4th Department case law support. The limited situation I give you an example of. So let's say during cross, you insinuate that the witness first said that a person slipped and fell, but then that person gets arrested for their own case, and then they change their story, well, actually, I witnessed an assault. And the reason that they changed their story is that so they could testify against your client and receive a benefit in their own case. That's a recent fabrication. And the prosecution would then be able to show any statement that predates that witness's own arrest, wherein they said that they witnessed an assault. Does that make sense? Okay. And the foundation is where and when the statement was made, the tenor of the statement, and the important part is that the statement preceded the motive on the part of the witness to fabricate. So in this case, the prior consistent statement would have to precede the witness's own arrest. So it's something to keep in mind when you're cross-examining witnesses. You want to walk the line between hammering them with their inconsistencies, but you don't want to get into the recent fabrication if you know that there are prior consistent statements that the DA will be able to get into. I would also keep this case with you if you anticipate a vigorous cross-examination with inconsistencies, because if the DA then tries to use prior consistent statements, you want to be able to show the court that no, just because I cross-examine this witness effectively, they're not able to bring in prior consistent statements. People v. Harris, Your Honor, it's right here. I have 3 copies, one to keep myself, one for the court, one for counsel. And then the DA is going to run up to the appeals bureau with their hair on fire, and you get a little victory in the middle of your trial. So just keep that in mind, because you will find from time to time the DA is trying to do that. Documentary evidence. It's the same formula. R plus R equals A. Relevance plus reliability equals admissibility. So in general, the steps for admitting a document, and as I look around this room, I think all of you know this, but we'll go through it. You have the exhibit marked. If possible, you do it before the witness takes the stand. It just breaks up the flow of your direct or cross-examination a lot less. If you have your exhibits pre-marked, the courts appreciate it and the stenographers appreciate it. And it applies on cross too. If you know a witness has taken the stand, you know that you're going to use 3 different things during cross-examination. When the DA is having whatever pre-marked, you can go up there and have your exhibits pre-marked too. And I think it will break up the flow of your cross-examination a lot less. It can be effective to do. But anyway, you have the exhibit marked, if it's not already marked, show it to opposing counsel, place it on the record that you're showing it to opposing counsel. You approach the witness and say, showing you defendant's exhibit A for identification. What is this exhibit? If you're worried that the witness won't know what it is or say what it is, I've done it before, you can say, showing you defendant's exhibit A, is this the transcript of your grand jury testimony from whatever date? And they'll almost always say yes, especially if it's during cross-examination. And then you lay a foundation for admission, depending on what kind of evidence it is, and we'll go through those. And then once you're done, you move it into evidence, and you have the stenographer mark it into evidence before you continue with more questions. So private writings, these are like a letter somebody wrote to somebody, an email somebody wrote to somebody. There are different ways you're going to be able to do this. Number one, it matters, well, this would be, the first situation is a witness actually saw a defendant write something or type something or whatever. You don't get that too often, but I've seen it before, I've had it before in my cases. So you'll ask the witness, where and when did you see the document being created, by whom, who else was present, what took place? Well, I saw the defendant write, I'm going to kill you on this piece of paper and hand it to the bank teller, whatever it is. The witness then recognizes the exhibit as the same exhibit that was created in his or her presence. It's in the same or substantially the same condition. And then you can enter it into evidence on that basis. That's going to be pretty rare. A lot of times you're going to have to find different creative ways to enter a document into evidence that was written by a witness. So it can be accomplished by circumstantial evidence, and that applies to emails. Really, the question you're going to want to answer is, how do we have sufficient assurances that the person in question prepared this document or prepared this writing or wrote this document? A witness who recognizes a person's handwriting can authenticate it. They don't need to be a handwriting expert. So I'm sure a lot of you have seen it. The defendant writes the wife a letter from jail, and it's there's an order of protection in place. The wife can simply testify, yeah, I recognize it as my ex-husband's writing. That's it. That's all it takes to get it into evidence. But that applies for us too. So a lot of these rules, as we go through in the case law, is stuff where stuff came in against the defendant. But what's good for the goose is good for the gander. So we can use that case law to get evidence in ourselves. Yes?
Wouldn't this only cover the authentication part, not the hearsay part?
The question is, would it only cover the authentication part, not the hearsay part? That's true. But a lot of times, and the judge is going to go through what is and isn't hearsay. Just simply because someone wrote a letter out of court certainly doesn't mean that that letter is hearsay. Because if it contains commands in it, if the mere writing of the letter, in the case of if there's an order of protection, there's a lot of situations where it can be relevant and non-hearsay. But yes, we're only talking about authentication of the document at this point. The judge is going to go through hearsay. So all you're thinking about is, how do I prove sufficient evidence to justify the inference that a particular person wrote this letter, email, whatever it is? Examples are knowledge of something only that person would know, use of nicknames that only that person uses, etc. And later on, we're going to talk about emails and social media a little more at length.
Can I interject on that one?
Yes.
I had a case a few years back where it was a domestic violence case. Defendant was charged with an assault of his girlfriend. He was in jail. He was reaching out to her from the holding center by letters that he didn't write. So it's kind of a Cyrano de Bergerac situation where I'm guessing he was dictating to his cellmate or whatever. And that letter, though not in his handwriting, was chock full of private references that were known only to him and to the complainant. And so I let it in based on circumstantial evidence supporting authentication. Fourth Department bought it, so it's good law.
Business records, in the interest of time, I'm just gonna pass this over. There's some overlap between the judge's presentation and mine, and he'll talk about that when he talks about hearsay. The main thing to know about business records, though, and I don't know if a lot of people know this, including judges, if the defense is offering a business record and there's a proper certification with all the prongs in CPLR 4518, you don't need a live witness. You can just have it marked, it's got the certification, enter it into evidence. That's all you need to do. So just be aware of that. And there will be support, case law support coming up in the next couple of slides that you can use to respond when the DA doesn't agree that that's the case or the judge isn't aware that that's the case. There's our first code for the people live streaming at home. I'm going to leave it up while I answer Terry's question.
Well, on that last one, the certification, that's, the 4518 language is important because a lot of times the certification isn't enough. It's insufficient to meet those
Right.
requirements.
And so the question was, sometimes the certification prepared by, say, the company that you subpoenaed the records from doesn't comply with the requirements in CPLR 4518. And that's true. And if that's the case, you'll want to think about that and maybe prepare your own certification and send it to them and have them sign it, whatever you need to do. Same applies with hospital records or bills. CPLR 4518 B or C. Again, you only need the certification. And it just has to be a hospital bill or record with an attached certification stating that the signatory is a hospital official and that the document is an accurate bill or an accurate copy of the hospital records. So if you wanted to get, say, your client's own medical records in without calling a doctor or without calling your client to the stand, if you get a certified copy of the records to show that your client had a black eye that day or was beaten or whatever it is, whatever helps you in your case, you can do that. I would consider calling the doctor or medical professional anyway because it may provide more value to you, but that's an example of something you can do. So the practical way you do this, any evidence under 4518, so the business records, whatever, you just have it marked, show it to opposing counsel, put that on the record, offer it right into evidence. And if there's an objection, there almost always will be. You say, Your Honor, live testimony is not necessary under CPLR 4518. The certificate satisfies all the requirements, and I cite People v. Kinney, Court of Appeals case that's in your materials. Fred.
Copies of the certificate, not the original certificate, but a copy of it.
Copies of the certificate? You don't need like a raised seal or anything on that. So as long as you have a certification, they'll always send you the certification will be an original, and then they'll send you a copy of the record.
We're talking about sometimes the DA will present a certification that's a copy of the certification. You can tell it's a copy.
Well, then you're getting into best evidence rule stuff, which is, it could be a topic of its own 1 hour presentation, so I don't want to really go down the rabbit hole. Joe.
Rather than take the risk that there's going to be a certification issue, this is prime for stipulations, I think. So that if you have to disclose it anyway to the prosecutor, it comes time for trial, I think the best course is to try to get a stipulation.
Right.
So that you don't run into those issues anyway. They've got it, you've got it. What's the issue?
Right, and if you do have the proper you have the proper certification, and you can show the DA that, you might be able to get them to stipulate. Especially if you're willing to stipulate to something with them that the drugs were taken to the lab and put in the lockbox by Officer Smith. What do you care? You're not arguing that Officer Smith tampered with it. So sometimes you'll be willing to accomplish that. Amber.
So there were some recent amendments to the CPLR within the last 12 months, talking about in circumstances where there's disclosure between the parties prior to the trial. And I can't remember the section off the top of my head, but just like the Family Court Act would borrow from the CPLR when it doesn't have its own structure. So disclosure is one of those things. Article 31 is kind of incorporated in the Family Court Act, because they don't have their own technical disclosure that they abide by. So using that as a springboard, if something is not provided for in the CPL, you would then be looking to the CPLR to kind of fill in the gaps. There is a recent amendment that states that if something is disclosed and the other party is then offering that at a trial, it's automatically admissible, subject to the party that initially provided the disclosure stating that it's either not reliable or some other way. Is this something that we should be focused on or using, especially when we're trying to get something in and maybe we don't have the right seal with us, or we don't have something that maybe we should have gotten or didn't have time to get? Is there something we can use like that to shoehorn it in and then basically challenge the DA to be like, you tell me why your disclosure to me isn't reliable?
So the question is, I believe the question is, if the DA gives you something, is it automatically admissible? The answer is no. There may be something in the CPLR that says that the CPL governs admissibility of documents that are disclosed. And no, just because the DA gave you something doesn't mean it's admissible. R plus R equals A, not DA gave me equals A. I wouldn't stand up in court and make that argument. Judicial notice, only, we're gonna fly through this because I wanna leave the judge some time. And we're getting a lot of long questions. Facts that are capable of immediate and accurate determination by resort to accessible sources or areas of common knowledge, statistical data, public records. You have to make the request. The party wanting notice has to make the request. The court won't do it sua sponte. Things that the DA may try that you can stop them. Value of property, car stopping distances, driver reaction time have all been held to be improper subjects to take judicial notice of. Official documents, the foundation is in CPLR 4540. It's got to be a copy of an official record. Certificate needs to be attached. And all it has to be is a public custodian who signs and says it's a true and accurate copy of the original official record. There also needs to be a seal. And if you have all that, it comes in without live testimony. So official documents, the only difference is it needs a seal affixed to it. Photographs are the easiest thing we're going to talk about. Good news there. All that has to be established is that it's a fair and accurate depiction of the object or the scene at some relevant time. It's usually by a person who saw the scene or the object at or around the time of the event or the time the photograph was taken. But that's all it takes. It doesn't. The photographer doesn't have to be called. Nothing like that. Video is a little different. So one way is it can be the same way a photograph's authenticated by someone who viewed the event and can testify it's a fair and accurate depiction. I'd say that's the most common way. But let's say you have a surveillance video at your house and it shows someone burglarizing your house, but you weren't there because you weren't home. The burglaries happen when people aren't home. How would that evidence come in, I guess? It can be any testimony that can establish sufficient assurances that the video truly and accurately represents what was before the camera. So it could be things that have held to be okay would be a building maintenance superintendent who is familiar with the premises and the surveillance system, or a testimony of a homeowner who had a surveillance system installed and was familiar with the home. Now, the last thing we'll talk about is social media and text messages. And this is maybe the most important thing that I'll talk about. But the Court of Appeals has held that just the name and picture on a profile page without more is not enough. Because I could make a social media page with a picture of Terry Newcomb, put my name in as Terry Newcomb, and send all these offensive messages to everybody, and nobody could stop me from doing that, right? So it would be improper to allow that into evidence against Terry.
That wasn't you, Terry?
But any circumstantial evidence would be allowed to make the necessary link, such as some examples: the person's prior use of that account or website, or phone number, depending if it's a text or a social media account or an email address. Prior correspondences from the person in question from that account or phone number. So some witness who says, yeah, I've received an email from Terry Newcomb from that account before, and I know it was Terry because X, Y, and Z. Whether the account is password protected, whether it's tied to any devices owned or possessed by that person. So, if you can say, yeah, well, we could look through Terry's computer and see it was logged in as that username on that website, that would make sense to provide the link that it was Terry who actually made that social media account. Whether other people may post things to the account or only the user. So you can be creative when you're trying to get social media evidence in or text messages, things like that. And we'll go through some examples. These are some things that I came up with. At the beginning of cross, again, that's when you want to get your concessions. Prior to asking any challenging questions, you can ask the witness just offhand, like, you're asking them a couple easy questions. You mix in, oh, and by the way, your phone number is 716, whatever, right? And they'll say, yeah, it is. Or your Instagram name is John Doe 3838, right? And then go on to some other questions. And then later on, you can hammer them with that Instagram page where they said something that impacts on their credibility. It ties any correspondence from that account to that witness. You can ask any witness who received the correspondence questions that indicates it had to come from that person in question. So you're familiar with John Doe. You've communicated via text with him in the past. You've sent messages. You've received responses. On such and such a date, did you receive a message from that same number that you knew belonged to John Doe? That's going to be enough. Some examples from case law are in your materials. I'm just going to talk about a couple of them, but you can go through them at your convenience. Messages were properly authenticated where screenshots were identified, and the messages made no sense unless sent by a defendant. Again, a lot of this is going to be evidence that came in against the defendant, but that's the nature of our business. We have to use that then to our advantage when we want to put evidence in. An electronic video was authenticated where it was identified by an officer who viewed it online and by distinctive characteristics of the video. Printout of text messages taken from a victim's phone were authenticated by testimony of the victim that the printout accurately represented the exchange of messages. Instant messages were authenticated by testimony of the victims that they texted with the defendant, testimony by the investigator that texts were retrieved from victim's computer, and testimony of MySpace compliance officer that the messages were exchanged between those accounts set up by the defendant and the victims. And instant messages authenticated by witnesses who identified the defendant's screen name and picture. The contents of the messages indicated that the sender had direct knowledge of the crime. So that's kind of you have to be creative and think of how am I going to link this witness to that. But I think your best bet, because these are often prosecution witnesses we're cross-examining, just ask them early on in your cross-examination, oh, by the way, your email address is this, correct? And, they're not thinking at that time, oh, he's got all these emails, he's going to hammer me with those. And when you're doing it, you can even have a piece of paper in your hand or pretend you're reading from something, because then they're thinking, oh, well, if I lie about this, he's going to be able to prove I'm lying. So you can often link them during your cross-examination. But I would have a backup in mind in case you can't get that witness to admit that that's their email address, phone number, whatever it is. Does that make sense to everybody? All right. And then the last thing, physical evidence. There's just a distinction between fungible and non-fungible and how it can come in. This is my engraved ring that was stolen. It's in the same or substantially the same condition as when I last had it in my house. I recognize it as my ring. That will then come into evidence with no chain of custody. If it's a pile of money where the serial numbers were never memorialized, though, or something that's been mass produced, they have to establish, or you have to establish, if you're the one putting the evidence in, a chain of custody in order to get that evidence in. Keep in mind that minor gaps in the chain of custody will go to the weight of the evidence, not the admissibility. So they have to have, or you have to have, a substantially complete chain of custody, but not, if you're missing one little gap in the chain of custody, it's not fatal to you entering that evidence. Does that make sense? Okay. Any questions as we put the next code up for the live stream viewers? You people here don't have to worry about that. You're watching it live. Any questions on anything that I presented? Okay, we're going to take a break. I just ask that you really keep it to 5 minutes here because we ate into the judge's time a little bit, and we don't want to keep you late. So keep it to 5 minutes, come back in at 2:15, and we'll get on with the hearsay part of the presentation.
I got a call from Dave Wilson on.
That will be to either today or yeah, I think it might be time. Right.
Hey, I heard Peter Crosby. So they're gonna make the check, supposedly. Tell them that, what's the check?
That's way on. Remember,
They start getting
It sounds like the foundation.
You're not that down to
Especially since your client other information about which this would be. Jury can read it, because it's inevitable.
Jerking him around. Yeah.
Right.
Now you want him to stay for a blender wants him to erase it.
Yes.
Their claim is that it wasn't.
Are you sure you can? And the other one was the same. One of them things.
Overdue. I remember that.
Okay, guys, let's resume because I have about 3 hours of material now. It runs into one. Good luck with that, right? Welcome, everybody. Welcome back. Let me begin by advising you, if you don't already know, if I can have your attention, please. NewYorkCourts.gov. Write that down, and when you need to find a good, concise, up-to-date statement of the rules of evidence, go to the rules of evidence at New York Court, nycourts.gov. Reason I know that is because I've been a member of that advisory committee, and you have a statement of the rule, and you have annotations underneath it with the best case authority from the Court of Appeals. It'll save you a lot of time, and at the very least, it'll get you on first base. So anyway, it's my pleasure, as always, to be here with all of you. I'm going to talk about hearsay and some exceptions, and hopefully talk a little bit about the confrontation clause, which is hard to avoid when you're talking about hearsay in the context of criminal prosecutions. Whenever I speak to folks about matters of evidence, whether it's law students, trial lawyers like yourselves, judges, or people who've got nothing better to talk about, I always find myself going back to the basics. Not because I think the people I'm talking to don't understand the rules of evidence, it's just that honestly I have a hard time keeping track of them all, and understanding and remembering the nuances and the differences, for example, between an excited utterance versus a present sense impression, statement of a party opponent versus a declaration against interest. Sometimes things get jumbled, it can be confusing. And I remember not too long ago when I was on the bench, I'd be presiding over a trial, and my reverie would be interrupted by an attorney. Objection, Your Honor. Hearsay, or foundation is lacking, or best evidence rule, whatever the case might be, and I would have a moment of cognitive paralysis, and then eventually the wheels would start turning again, and the evidence rules would be spinning in my head, kind of like the fruit one of those one-armed bandits. And eventually, I think about it and then say something intelligent like, "Oh, it's cross-examination. I'll let it in," or we'll just hear it for what it's worth. Sometimes like to say that for what it's worth. You're killing my client. But I would always take comfort in knowing that the standard of review is abuse of discretion. So I always felt like I was on a reasonably good footing for the most part for appellate purposes, and then you also have that fallback of harmless error. But in all seriousness, the reason I think it's so important to go back to the beginning every time is not only that we as lawyers are on the same page, as the judges should also be, but so that when you decide that something is important enough to object to, because it's harmful to your case, that you know the right rule. And so you can keep things out that are harmful to your case, or at the very least, preserve the record for appeal so that the argument is available to appellate counsel in the event of an adverse determination. So, starting back at the beginning then, very quickly, let's go through the rule that we can all recite in our sleep. We learned it in law school. It's kind of like the Pledge of Allegiance, right? Hearsay is an out-of-court statement offered to prove the truth of the matter asserted therein, and justice and liberty, or whatever, liberty and justice for all, right? But what does it mean? Let's quickly break it down. When we say it's an out-of-court statement, very simply what that means is that it is a statement that was made at a time and place other than from the witness stand. Common example, you have a police officer on the stand on direct examination. Officer, you responded to this DWI accident case, did you not? Yes. And what did you do when you got there? I surveyed the scene and I identified who the witnesses were, who the drivers were, and I spoke to whomever. I spoke to a bystander. And what did the bystander tell you that she saw as to the happening of the accident? That's a logical place to articulate a hearsay objection. Now, maybe it's an excited utterance. Maybe it was, maybe not so much a present sense impression. We don't know because we'd have to know what the foundation is. But that's the kind of out-of-court statement that's most common, where you have a witness on the stand who's testifying to something that somebody else said, either to that witness or in that witness's presence, that he or she is being asked to recount at the trial. But, as I think Nick already alluded to, don't assume that just because the declarant, the person who made that out-of-court statement, is on the stand and subject to cross-examination, which is always one of the concerns about hearsay, because typically you can't cross-examine the declarant. But when the declarant is sitting on the stand and he or she is being asked to testify to something that he or she said before about the matter in question, it's still hearsay if it's being offered for the truth of the matter asserted. And so if, for example, that bystander was on the stand and was asked, okay, well, tell the judge or tell the jury what you saw about how this accident happened. The witness goes through that. And then did a police officer come to the scene? Yes, he did. And what did you tell him you saw when the officer asked you about what happened? That's another example of hearsay, albeit from one who's on the stand, subject to cross-examination. But as Nick already alluded to, unless there's some exception, that ain't coming in, A, because it's hearsay, and B, it's probably improper bolstering, repeating a prior consistent statement that has not been challenged in any way, shape, or form. In People versus McDaniel, I believe it is, Court of Appeals said that a falsehood does not become true by sheer force of repetition. Now, after the past year watching national news, I'm not so sure that that's true anymore. But the fact of the matter is, prior consistent statements don't come into evidence unless, as Nick suggested, the witness is called on the carpet on cross-examination and the lawyer saying, wasn't it fact you're making this up today, or this is something that's a recent fabrication. Then, as Nick indicated, you may be able to introduce that prior consistent statement if it predated any motive to fabricate, basically to offset that claim of recent fabrication. And then it says an out-of-court statement. And so what do we mean when we say statements? As you all know, it's most commonly an oral statement. Somebody said something to somebody else. but it can also be written, it could be in an email, in a letter, in some other documentary form. But also remember that hearsay can consist of conduct. All right, as long as it's assertive in nature. Because if you look at the rest of the rule, it says hearsay is an out-of-court statement that's offered to prove the truth of the matter asserted therein. So, in order to be hearsay, it's not so much what the content of the statement is or the conduct or whatever the case might be, it's what is it being offered to show. That's why judges will often ask the attorneys, well, where are you going with this? What are you trying to prove? What's the probative value? And if the statement is being offered to prove that which it asserts, for example, that the car was speeding, it was weaving all over the road, it drove through a red light, the weather was wet, whatever it might be, if it's being offered to prove the substance or the truth of its content, then you got a hearsay issue. So when you're evaluating any statement to decide whether or not it's hearsay, it comes down to what's it being offered to prove. And if it's the truth of what it claims, then you got a hearsay issue. So how can conduct be considered hearsay? Well, let's say police officer goes to that scene. The person who was in one of the vehicles is injured behind the wheel. Let's say that the defendant fled the scene, and the officer's communicating with that injured driver. And did you see where the other driver went? And the person goes like so and points in the direction to communicate the direction of travel. That is an example of nonverbal assertive conduct, which is the equivalent of hearsay, because it's trying to convey that fact that this is the way the defendant traveled. Now, if the witness goes like this, you could probably argue it's not being offered to assert anything in particular other than the fact that the witness doesn't know. But nonverbal conduct certainly can consist of hearsay. I think I've got a couple examples in there somewhere where I talk about Paul Revere and the two lights in the church tower to indicate they're coming by sea. And if he's observing it while it's happening, maybe it's a present sense impression, but that might be an example of nonverbal assertive conduct because it's intended to communicate a message. Another example is, let's say you have a little break between popes and they elect a new pope and then there's white smoke coming out of the chimney. Huzzah, we've got a new pope. That's a communication. Whereas if you walk by somebody's house and you see smoke coming out of the chimney, they'd say, that could be hearsay. You'd say, what are you talking about? You're out of your mind. So my point is you can have hearsay that is not verbal. Also, and I heard Nick mention this already. When there's somebody makes a command that says, go here, do this, don't do that, walk this way, whatever the case might, that is generally not a hearsay type of a statement because when somebody gives a command or a directive to somebody else, you're basically just telling them to do something. Back off, get out of my way. But you're not asserting a fact that's necessarily capable of being proven true or untrue. So it's not assertive, therefore it's not, generally speaking, hearsay. Also, questions, interrogatories are generally not considered to be hearsay because they don't assert facts, they ask about them. Where are you going? What time is it? What are you doing here? However, you have to be careful for and be on the lookout for hearsay that's buried in a question, which may not be a question at all. Let's say a defendant is being tried for unauthorized use of a vehicle. Let's say he stole his neighbor's car, and the other neighbor sees him in the car and says, hey, what are you doing driving Bob's car? It's a question, but built into that question is the assertion, you're driving that guy's car, and it's an element of the crime, and if it's being offered to prove that the defendant was driving the neighbor's car, you got a hearsay problem, so you better be looking for an exception, otherwise it ain't coming in. So, at the risk of being redundant, look to the purpose for which the statement is being offered, and that'll help you decide whether or not you got a hearsay problem at all. Because if it's being offered for some purpose other than the truth of what it asserts, it's not a hearsay situation. Okay? Then you've got a relevance question to deal with. Okay, if you're not offering for its truth, counsel, what are you offering it offering to prove? Well, it could be this, that, or the other, but it better be relevant to the issues in the case. So some of these, I have some illustrations of other, I'll call them non-hearsay purposes. In this People versus B Coats case, defendant was on trial for murder and robbery, and he wanted to call a witness to say, well, I overheard a co-defendant and another person talking about a plan to rob the victim. And it was a hearsay objection, and the defense said, well, we're not offering it to prove that these people were actually involved in the robbery. We were offering it to prove that our client was involved in any planning or preparation, which makes it less likely that he was involved in the crime. And the Court of Appeals said that would have been admissible non-hearsay. Other examples are the listener's state of mind of the declarant, or Nick talked about it, to impeach. And we mentioned it, that when you bring in someone's prior statement, which it could otherwise be hearsay, you're not offering it for its truth, you're just trying to show the inconsistency. In sexual assault cases, as I'm sure you're all familiar, prompt outcry is a non-hearsay purpose, where the victim is allowed to testify that she or he, as the case might be, within a reasonable time after the incident, reported it to somebody else, whether it's family member or police. That's a policy rule more than anything else, because so often victims are impeached for that very reason, that they waited so long before they told anybody, or they didn't tell anyone at all until much later. So prompt outcry, which means the fact of the complaint but not the details, would be admissible non-hearsay. I think you probably have already noticed, those of you who do domestic violence cases and sex abuse cases and child abuse cases, that the rules of evidence are much more elastic in terms of the type of testimony that's allowed in that might not otherwise see the light of day in a more generic kind of case. For example, in child abuse cases, in the cases that are cited there, Cullen and Ludwig, police witness is allowed to testify to what the child victim said happened to her and who did it. Not for the truth of the matter asserted, but according to those cases, to explain the narrative of the police investigation and how it leaded up to the defendant. It's pretty damning stuff. And I always wonder when judges give cautionary instructions. Now, you're not supposed to consider that testimony for the truth of what she said, that this guy sexually abused her, just to explain why the police did what they did. I mean, honestly, the appellate courts assume that jurors follow those instructions, unless the record indicates otherwise. But I think that, from a human point of view, once that bell is rung, good luck unringing it. Another non-hearsay purpose might be, and I'm sure you've heard this before, either statements that are verbal acts or so-called, they have legally operative effect. So, for example, if the defendant is charged with robbery and he says as part of it, put up your hands, this is a stick-up, it's technically hearsay, it might be considered admission because it came from the defendant, but those words have legally operative value because they're an element of the crime, because you got to show forcible compulsion, which can include a person's words. Or if you have an illegal transaction between two people, whether it's a conspiracy or whatever, an illegal agreement, those words have legal effect, or in that case, illegal effect. Or if you have conduct that's ambiguous. Let's say police officers are surveilling two people on a street corner, and one hands the other money, and the other one extends his hand, and they think they're looking at a drug deal. But actually, there's a witness who hears them, and one says to the other, well, hey, Bob, happy birthday. Many happy returns. Those words, which are hearsay, arguably, they have the effect of explaining the conduct. So they're a verbal act. Or if the person says, all right, here's your $1,000, but if I don't have it paid, if you don't give me $1,200 by Tuesday, I'm going to break your legs. That tells you what the nature of that exchange was. So those are words that have legally operative effect, or explain an ambiguity, or put meat on the bones of the conduct. Case Caban here says that if a defendant accepts a co-conspirator's offer to commit a crime such as murder, that offer and acceptance constitute a verbal act. It's not hearsay. Evidence of the unlawful agreement. This Huertas case is pretty interesting. I remember when I first read it, I thought to myself, boy, oh boy, this gives a lot of good latitude to the prosecution in a rape case where the rape victim's hearsay statement, her initial description that she gave to the police of the rapist, was admitted into evidence not for its truth, but to give the jury the wherewithal to evaluate the reliability of her subsequent identification of the defendant, like 12 days later. So, in other words, they said when you compare how he looked with the description that she gave, that would allow the jury to assess the accuracy of her perception and the quality of her recall. I mean, I'm convinced that when the courts want evidence to come in, depending on the nature of the case, they will find ways to get it in. But so here you have a case where a hearsay statement where the victim described the perpetrator to the police is admitted, and they say not for the truth that he's the guy, but just so that the jury can decide whether or not it's a reliable identification. I think we already talked about this. So here's the hearsay rule. It's not admissible, assuming it's being offered for the truth, unless you can find some exception, and there are many. There's one, though, that you don't hear mentioned often, and this, I guess, might be the last bastion when everything else fails. But it's the federal and New York constitutions require the admission of hearsay not encompassed with any particular hearsay exception when these conditions are met. Declarant is unavailable, the hearsay evidence is material, exculpatory, and has sufficient indicia of reliability. And on the theory that a defendant has a constitutional right to present a defense. I don't know how many times that's been raised or argued, and I think judges would be a little bit, unless there's real evidence of reliability, I don't know how many judges would be willing to allow, hearsay evidence to come in from an unavailable declarant, but it's in there. And occasionally, inadmissible hearsay may be allowed to when the door is open to otherwise inadmissible hearsay, sort of like to clear up the record and clarify a misconception that may have been created. In this People versus Reed case, defendant was on trial for murder. His co-defendant's case was severed because the co-defendant had implicated him, so there was a brutal issue. And the defense was able to get out information from the police investigator that he had heard from some witnesses who claimed that they had heard that somebody else was actually involved at the time of the murder. And so what the court then allowed the prosecution to do was to allow the prosecutor on redirect of the officer to say, well, isn't it true that you had firsthand information from somebody who was actually there that other person that these witnesses claimed was there actually wasn't there? So you're battling hearsay with hearsay. Two wrongs apparently making a right, I don't know. But the court said that the defendant pretty much opened the door to it and waived any confrontation clause issue that he might otherwise have. So you just got to be careful. If you're going to bring in hearsay, don't be opening the door too wide to other damaging hearsay. All right, so let's talk a little bit about excited utterances and present sense impressions. They're very similar. You often hear them raised in tandem or in the alternative. Sometimes they're confused. So it's important that you understand the distinctions and the rationales for their admissibility. An excited utterance is a statement about a startling event, whether it's shooting, stabbing, robbery, auto accident, whatever applies. The statement is made by a participant in or bystander to that event. It's admissible whether or not the declarant is available. So the declarant may be a witness in the trial, but that prior statement, if it qualifies, it may come in anyway. If the proponent of the evidence shows that this statement was made under the stress and nervous excitement resulting from the event. rather than it being the product of quote-unquote studied reflection and deliberation. So the thinking behind this rule, as I understand from the cases and so on, is that the person's ability to deliberate and fabricate have been temporarily paralyzed, so that they're not likely to make something up. The courts really don't say too much about accuracy and perception, because when someone's excited and adrenaline's pumping, their perception may not always be accurate. But that doesn't seem to be a major concern in the cases that I've seen anyway. But it's you have to look at the nature. Well, the factors that the court will consider will be to look at the nature of the event. Is it the type of event that you would expect to be startling or exciting? How much time has passed between the event itself and the statement made by the declarant is a factor. But you're going to see that excited utterance are not as time sensitive as present sense impressions. But the more time that passes, the less likely it is to be excited, because people usually calm down over time, right? And there should be an element of spontaneity to it. That doesn't mean, however, that just because someone's being asked questions by the police or by the 911 operator, whatever it might be, that takes it out of the realm of an excited utterance. Because usually what happens in a 911 call, the person, calls all bent out of shape about whatever happened, and they're asked a lot of questions, and they answer them. So the fact that questions are asked won't necessarily eliminate the exception. But I think more important than the passage of time is what happened in the meantime between the event and the statement that was made. So the more opportunity that the declarant has to have interaction with other people, which implies that they've had time to think about what happened and communicate it to others, that might take it out of the realm of an excited utterance. There's one case, I think I cited somewhere. It's a family court case, the matter of O'Dallas F. Kid got in a fight with his brother, the brother stabbed him, but before the kid called 911, he called his mother first, told her what happened. She came home, and he goes, well, what should I do? She goes, call the police. So he called the police, and the court said, well, too much time and intervention took place. Also, when you're looking at foundations that you have to build to get it into evidence, or when you want to keep it out and you want to see if the prosecution is hitting all the marks, the declaration has to be made based on personal knowledge rather than hearsay or speculation. Okay, and in this Cummings case that I cite there, fairly recent one, it was a drive-by shooting. Somebody calls 911, and in the background, somebody said, yo, it was so-and-so who did it, citing the defendant's first name. And the court said it was error to admit that because it wasn't so much that the declarant was unknown, which is a factor, but that there was no way to know whether or not what he was speaking about was from personal knowledge or what somebody else told him, or was he guessing? Who knows? Couldn't say. So the foundation wasn't there. So there's an element of spontaneity, as I mentioned, and personal knowledge is important. Oftentimes, confrontation clause issues will arise in the context of 911 calls, excited utterances, and the analysis you have to do is whether or not the questions that were asked of the person were intended to help to meet an ongoing emergency, or was it just to gather and develop evidence with an eye towards future prosecution. So present sense impression, then, the best analogy I can give you, I think of a play-by-play announcer. Think of, I'm going to date myself here because Van Miller, when I actually used to listen to the Bills in earnest, he was still a play-by-play guy. And I remember how he would, you could listen to the radio, Kelly's in the K-gun formation, you got Andre Reed split right and James Lofton to the left, empty backfield, long snap count, describes the play as it's unfolding. To me, that's a classic illustration of a present sense impression. Describing an event or condition as it's being perceived by the declarant or almost immediately thereafter. So present sense impressions are much more time sensitive than an excited utterance. Okay, compare the present sense, the play-by-play with what you hear at halftime or at the end of the game when they're doing the recap and the analysis, talking about things that happened in the past, so to speak. But the rule then is that if a present sense impression is admissible, whether or not the declarant is available to testify, as long as it's describing something as it's happening or immediately thereafter, seconds, couple of minutes. There's one case that says 7 minutes was too long. Things that time had already passed, too much time to reflect, that kind of thing. But there has to be corroborating evidence for a present sense impression. Corroboration of the event itself and the fact that the statement was made very close in time to the event as it was unfolding. It says that contemporaneous pretty much means just that, with a little bit of flexibility, but not very much. So, and the person must be describing something that he or she has perceived with first-hand knowledge. It can't be based on speculation, hearsay, or anything like that. So this gives you this page will give you a brief summary of the differences between the two. Excited utterances being the product of that person's exposure to the startling, upsetting event that disables the powers of reflection, whereas present sense impressions are descriptions of events made by a person perceiving it as it is happening. So I guess the event wouldn't necessarily have to be an exciting one, right, to be a present sense impression. And excited utterances are considered reliable because the excitement of the event stifles. I was tired of reading deliberation and fabrication, so I said cogitation and confabulation, which is basically thinking too much and making shit up. Present sense impressions are deemed reliable because of the timeliness of them and corroboration. Those are the key elements to admissibility, and it's considered that those factors minimize the risk of calculated misrepresentation and inaccuracies based on faulty memory. Okay, so my sense is I'm not going to get too far through this, but I'll forgive me if I'm sort of breezing over things. You have all the stuff in writing anyway, right? So you can read it at your leisure. Which begs the question, why am I here? Statements of a party opponent. I have occasionally heard lawyers talk about admissions against interest, and I think I know what they're talking about. But there are statements of a party opponent, sometimes referred to as admissions, and there are declarations against interest. They are apples and oranges. Don't confuse them, if you can. So a statement of a party opponent, statement of admission of a party, it must be of a party. How many parties are there in a criminal action? Terry says 2. Well, we know the defendant is 1. Who's the other? The state, exactly. But so can there be a party admission by the state? Who would that be? Because we know that the victim is a witness in the case. So if you're trying to get in a statement of the victim as a statement of a party opponent, that may not work. In federal court, I think the FBI might qualify as an agent of the government, literally and from an evidence point of view. But remember that it's got to be offered by the adversary. Okay? If you're offering your own statement, it's not an admission of a party opponent because you're not your own opponent. So that's why it's called statement of a party opponent. And it's made in the individual or representative capacity. It doesn't have to be based on personal knowledge. It can be stated as an opinion. And at the time the admission was made, it doesn't have to have been damaging to the person's cause. For example, if you have a defendant who's interviewed by the police, accused of, or they're saying, well, did you assault so-and-so? I had nothing to do with it. Then things develop down the line, becomes a matter of self-defense. Well, that prior statement, which maybe at the time was self-serving, is now contrary to his interest at trial, because now the people can argue that it's kind of an evolving story to suit his convenience. So my point is, it's the admission does not have to have been against that person's interest at the time it was made. It does not have to have been made on personal knowledge. It could have been stated as an opinion. The question is, what is it being offered to show now? And it's usually because it's being offered by your opponent because they think it hurts you. And the declarant party may or may not be available to testify. Availability is not an issue. New York State, I think, is one of 3 states in the country that still cling to the so-called speaking agent rule. And I think you encounter it more in civil cases than in criminal. But basically what you have, in order to have a statement of an employee, an agent, somebody who works for you, whatever, to be admissible as against the principal, you have to show that that individual, the declarant, not only had the authority to do whatever it was he was doing, but to speak on the issue. Like I said, I can't think of too many instances where you deal with it in a criminal case unless you have a corporate defendant, for example, and one of the employees made a statement that was damning to the corporation. The proponent would have to show that that person was authorized either expressly or by virtue of the authority conferred upon him in terms of responsibility over the operation of the place to speak on the topic. Sometimes admissions can be adoptive in nature, where the person hasn't actually said something but behaves in a way that manifests his acquiescence in or acceptance of something that somebody else said or did. You got 2 drug dealers. One says, "Hey, my boy over here can get you some really good shit." And the other guy goes and gets it and brings it over, hasn't said a word. That's an admission by adopting what that other person said is basically attributed to him by virtue of his conduct. Or let's say you have an auto company that gets a report that says your airbags are defective, and they do a massive recall of these cars. That conduct is a tacit acceptance of or an adoption of that information that was conveyed to them. So that would be considered to be an adoptive admission. An admission can also occur by silence. In the face of an accusation that could have and should have been denied, assuming the person was in a position to do so. This case that I cite here was a DV case, as is not entirely uncommon in those situations. Defendant calls I think it was his wife, basically trying to prevail upon her to drop charge, and she goes, "You broke my ribs, you asshole." And he said, "Would you please just drop the charge?" He didn't say anything about, what are you talking about? I broke your ribs. I didn't. No denial, nothing. Right, and that was his silence was considered to be an admission of the content of the accusation, admission by silence. But you have to show that he heard it, understood it, was in a position to refute it, no impediment to it, and he didn't do it. We all know about defendants. You can't use his silence against him. And however, if a defendant, let's say defendant's arrested, given his Miranda rights, subject to interrogation, gives a statement, and then he testifies at trial and sort of gilds the lily, adding exculpatory details not mentioned in the first interview that logically should have and could have been included, he can be impeached with that prior statement, just as any other witness could.
Sorry. I'm just showing the code for the people live streaming. I'll put it up for a couple seconds. I just wanted to get that up before 3 o'clock so that. Okay. We're good. We gotta go back.
Okay, I'm going to jump ahead real quick then to statements against interest. Statement against interest does not have to be made by a party. Okay, it can be by any declarant. Thing is, though, is that declarant has to be unavailable, dead, too sick to come, can't be found with due diligence, invokes privilege against self-incrimination. And it's a statement that the person who's now unavailable made that was against his or her interest at the time it was made. He or she knew it was against his or her pecuniary or penal interest at the time it was made. And there's also going to be corroboration of it. And the idea is that people generally don't talk against themselves or speak against themselves, say bad stuff knowingly that subjects themselves to harm, which sort of makes sense. So key elements: unavailable declarant, against interest at the time the statement was made. Declarant has personal knowledge of the underlying facts of the statement, and there are independent facts corroborating the reliability and trustworthiness of the statement. And courts will take a different view if the statement is being offered either against the defendant or in the defendant's favor. Okay? Assuming it's non-testimonial in nature and you don't have any Crawford issues, and a co-defendant, say, testifies, and he's limited to testifying, or the statement of that other party is limited to only that which is deserving to him, but to the extent that it may implicate the defendant, there has to be corroborating evidence to show that it's highly probable that statement is true. So it's a higher burden than if you're offering evidence in favor of the defendant, hearsay in the nature of a declaration against interest. This People versus Soto case is a fairly recent case where defendants on trial for DWI and leaving the scene of a PDO wants to call his friend to testify that she was the driver. And the DA says, well, if she does that, she's going to get charged. And they wouldn't ask the court to give her immunity, so they offered into evidence her statement to the defense investigator wherein she said she was the driver. And before she gave that statement, she said, well, I could get in trouble for this, couldn't I? And should I call a lawyer? And she was facing only 15 days for leaving the scene of a PDO if she was going to be charged with it. But the court said even though that was relatively minor, it was still a declaration against her penal interest, and there were facts in the case that supported the fact that she may well have been the driver. So there was corroboration. But when you're dealing with evidence, out-of-court statement, declaration against penal interest that's being offered to try and exculpate the defendant, the corroborating evidence need only show that it's possible that the statement is true, reasonably possible to be true. So it's a lower threshold. Oh boy. I'm going to suggest we pick another day, or I don't know, at everyone's convenience. So do you want me to stop, keep going? You can read this stuff, but
I would just, the business records and materials, possibly we talked about. We talked about the decision, the confrontation.
You want me to spend 5 minutes on the confrontation clause and we'll call it a day?
Yeah.
Okay, thank you. And I'm sorry, I think we've done bit off more than we did. So confrontation, it goes hand in hand with hearsay, but you have to keep the two separate in your minds, because even if you have a hearsay statement that meets the hearsay exception, therefore it appears to be reliable and should be admitted, that doesn't mean it's coming into evidence if it violates the confrontation clause. Okay, so the confrontation clause is not so much about reliability, but rather it's about just that, confrontation. The right of a defendant, A, to be confronted by his or her accusers, and B, to confront them through cross-examination. So the rules is, as stated in Crawford and any number of cases thereafter, is that hearsay, even if it's reliable hearsay, is not going to come in for its truth. That's the key. It's got to be offered for its truth, because if it's offered for some other purpose, then you don't have an issue here. But if it's offered for its truth, it's not, even if it's deemed reliable, if that statement is testimonial in nature and comes from a declarant who's not testifying at trial and doesn't qualify as an unavailable witness, who is also subject to the prior cross-examination, or at least defense had an opportunity for cross-examination, it ain't coming in. Okay, make a long story short. And so the question is what makes hearsay testimonial hearsay? A lot of different courts have written on it. They kind of beat around the bush. But as best I understand it, if it was obtained as part of an effort to try and gather information, evidence, with the idea or with an eye towards future use in a trial against the defendant, then it's testimonial in nature. Okay? Michigan versus Bryant talks about that it was obtained under facts obtained under circumstances which in totality objectively indicate there's a likelihood of it's going to be used in an ensuing prosecution. I'll give you an example. People versus Goldstein. Court of Appeals case involved a guy who was convicted of pushing a young woman from Western New York into a subway in New York City. Some of you may remember that case. Well, he pled not responsible. People retain an expert to testify to try and controvert his claim of not responsible. So as part of her preparation for trial, prosecution's expert interviewed 3 friends of the defendant who said not so pleasant things about him. So the trial court allowed that expert to testify to the hearsay that she relied on in forming her opinion that the guy was not suffering from a mental disease or defect that prevented him from whatever the standard is for not responsible. And the court said, well, that violated the defendant's confrontation clause rights because those interviews were conducted under circumstances that objectively indicated that these people who were being interviewed knew who they were talking to, was an agent of the state, state's retained psychiatrist, in preparation for her testimony at trial. So it was going to be used at the trial of the defendant's case. And because they didn't testify and were not subject to cross-examination, it was a violation of the defendant's confrontation clause rights. In Crawford, it involved statements made to the police not only by the defendant but by his wife. She said some things that helped him and other things that were not so helpful. And the court said introducing her statement without calling her as a witness violated the confrontation clause because clearly she was interviewed by the police in a formalized setting and they were investigating a stabbing. And so there's usually an air of formality to them. And the idea is gathering facts under circumstances which objectively indicate it's for the likely use in a future prosecution. But there's a number of cases which have carved out an exception, which I think I've already mentioned. And if it's shown that the primary purpose in obtaining this information from the witness, whether it's by 911 at the crime scene, in a hospital, and you've got an injured party as the case might be, where the primary purpose of that statement is to help the person inquiring meet an ongoing emergency, whether it's to get help for the victim, find this dangerous person who's at large, or to figure out the mechanism of injury for this little child who got scalded in a bathtub, or whatever it might be. If the primary purpose is to help the police in an ongoing emergency, it's considered to be not testimonial. There's any number of cases here which deal not only with the police, but also with medical professionals and also with teachers who find out from their little students that kids are victim of child abuse. And although they're mandatory reporters, courts say their primary purpose at that point is to find out what happened to them and get them help and meet an emergency and so on. There's also documentary testimonial evidence. So whenever there's a report from a lab technician or a scientist or whatever the case might be that involves gathering information that can be used to connect the defendant to the commission of a crime, whether it's DNA, blood alcohol content, fingerprints, you got to have the person who either did the test, observed the test, supervised the test. Otherwise, that witness on the stand is just a conduit for somebody else's hearsay. And all those cases tell us that you can't do it that way. I'll just end on this point here. Interestingly, all those breathalyzer documents, those when you get the reports from the person in Albany saying everything's in good working order, the chemicals are all up to snuff and so on and so forth. Even though those documents are necessary to be used at trial to lay the foundation for the admissibility of the blood alcohol result, those documents which are sent to the police department are considered not to be testimonial in nature, because at the time they are prepared, they're just this person's objective report of his observations made at the time. Basically, his primary purpose is to tell the police department that uses that breathalyzer everything's in good working order. Its primary purpose at that point is not to be used against any particular unnamed defendant to try and convict him. That's People versus, I want to say Peeler, but it's in. So I could go on, but we're supposed to be done, so thank you. You got time for a song or not? All right, I'll do
I know, right?
Not about evidence, though. This song is sort of related to evidence. Some of you may have heard it before. It's a song about a prosecutor, I guess you could say, who is preoccupied with the rules of evidence getting ready for trial. Can I say it's Saturday? Trial's just 2 days away. I'm petrified. I'm coffeeed out, my clothing stinks. I haven't really slept a wink. My brain is so fried. I know the case, I prepped the file, my trial strategy is perfection. But what if counsel spoils it all by saying something stupid like objection? There's hearsay leading questions asked and answered, no foundation and then relevance. What will I do while me so screwed if I can't get my photos into evidence? I practice every day, rehearsing arguments to make so that my meaning is true. But then I think it's all a waste of time because the frickin' judge ain't got a clue. If I'm overruled, I won't get fooled, I'll offer it subject to connection. Then maybe he won't spoil it all by saying something stupid like objection. It's tough to teach me to impeach. Defendants hardly ever reach the witness stand. I rarely cross-examine, never feast, always family in criminal land. I prep for months, I'd love just once to tear the witness into tiny sections. But what if counsel spoils it all by saying something stupid like objection? Objection. Objection.
Yeah, I'm in the early process. Yeah, I'll stay in touch. I'm in.
Sorry.